automatic vacation of stay orders in 6 months is a positive development for the cases which are at the threshold of the proceedings, both in civil courts and criminal courts. How the automatic vacation of stay is possible is what we are going to discuss today. We all know that the process of disposing of a case in India can take years. Inordinate delays in resolving cases have been caused by stays of proceedings resulting from interim orders of the higher courts. Generally, these orders remain in effect until they are vacated or a final order is passed. There is a tendency for litigants to use interim orders to stall the proceedings before a subordinate court as a dilatory tactic to maintain the status quo in their favor. 87% of India's pending cases are handled by the subordinate court, that is to say, the lower courts or the trial courts. A greater challenge faced by the judiciary and litigants today is the delay in determining the cases at the appellate level, which leads to endless waiting for determination of even at the trial stage of a case. Trials are delayed by an average of 6.5 years due to the stay of proceedings by the higher courts. A good news for the litigants is that in a case, that is in Asian Resurfacing Road Agency versus Central Bureau of Investigation, the Honorable Supreme Court of India addressed the issue of undue delay in trials caused by stays. The CBI noted that high courts take a long time to dispose of petitions after stay is granted. Additionally, the Supreme Court emphasized the accountability of courts while granting stay of proceedings and ruled that such matters should be disposed in 2 to 3 months without adjournments. A high court or a court below the high court, if ordered a stay of trial proceedings before civil and criminal courts, then that kind of stay automatically expires in 6 months unless it is extended by a speaking order in order to ensure a speedy disposition of such cases. This measure was taken by Supreme Court. According to MA number 1577 of 2020, in criminal appeal number 1375 to 1376 of 2013, the Supreme Court reiterated this direction on October 15, 2020. As a result, once the 6 months period is over, the trial courts can resume the proceedings without further notice unless the higher courts pass an express order extending the stay. The trial court presiding officers cannot be charged with contempt of court for proceeding in terms of trial when there is no further order from the higher court, most particularly after the 6 months period has passed after the stay being granted. Now, the clarity that should emerge is if the stay has to automatically get vacated after 6 months, then that case must relate to a case where the trial is pending. Kudos to the great order which in fact expedited the trials in the trial court. Thank you very much for your patient hearing.